Please invite the administration team in. Welcome the administration team. I will not introduce you one by one. Matters arising. Paper CB bracket 1871/141501 lists the issues to be followed up at the previous meeting on the 12th of May. And then there is this another paper is the CB1 871/1415 bracket 2 that contains the administration's response. Perhaps the PS can take us through the paper 871/1415 bracket 02 is a written response to the members' questions raised last time. The first question, you may recall that in the last meeting we discussed whether the SVF, there should be a deadline for redemption of the outstanding stored value. We have taken on board members' views expressed last time. And as we said in the last meeting, our objective is to ensure that the proposed regulatory regime would enable the payment industry to adopt reasonable business practices and that treat customers fairly. So in light of the discussions at the previous meeting, we have considered members' views, and we would propose a committee stage amendment to improve the clarity of the requirement, and that the licensee must redeem in full the outstanding stored value on the facility as soon as practicable after being requested by the user to do so, unless the monetary authority has given prior consent to the applicable company that this requirement does not apply, and that the company has stated clearly in this contract that the terms that the outstanding stored value is not redeemable, that prescribed deadline, any fee to be charged, and other related terms. So if that is the case, then prior approval from the monetary authority has to be obtained. Otherwise, all licensee must redeem in full the outstanding stored value as soon as practicable. So this is in response to members' concerns expressed last time. The MA will consider issuing guidelines to facilitate licensees to comply with the relevant requirement concerning the redemption of outstanding stored value, including the setting of fees. I hope that members welcome such an arrangement. Second item, last time members asked about the new section 8T2, and that requires an SVF licensee to provide the HMO with details of a material change without undue delay or within a reasonable period if the material change is likely to take place. The material change relates to whether the relevant to the licensee's ongoing fulfillment of any minimum criteria, ongoing compliance with the licensing conditions, and the obligation to ensure safety and efficiency of the SVF. It would be an offense for the person who contravenes this requirement without a reasonable excuse. 8T2 doesn't specify a specific period for the licensee to report this material change. We have looked into the proposed section 8S and also section 67 of the BO. In 8S, we require the licensee to provide information on, say, particulars like a change in the address. So it's reasonable to set a definite time period for the licensee to report on change in that particular regard. But then if we talk about 8T, we are talking about material change. That may involve a number of considerations or decisions. So we have to take a comprehensive view on this. And under Section 67 of BO, authorized institution has to report to the MA if there is any possibility that it is not able to meet its obligations. It will not set a specific time, but it sets only reasonable period. So we think that our drafting is good enough and we don't need to revise it. Now, thirdly, the members raised concerns on whether the HKM's supervisory enforcement powers are adequate. We want to say that here that the bill contains many amendments to empower the MA to request information or documents, examine books, accounts, and transactions, give directions for immediate actions, or for appointment of advisor or manager, and issue guidelines. These provisions will empower the MA to conduct, if needed, on-site examinations and off-site reviews, and to exercise appropriate supervisory powers timely and properly. We think these powers are adequate. Fourth item, last time members asked about the arrangements in relation to banks. Now, the banking ordinance now provides that no person shall issue a multi-purpose card except an authorized institution which has approval to do so. The BO also provides that a bank shall be deemed to be approved under a certain section to issue multi-purpose cards. In other words, according to existing mechanism, the banks do not have to get separate approval for issuing multi-purpose cards. This to migrate the multi-purpose card regime under the BO to the proposed regulatory regime for SFVs, we propose adding new section 8G to provide similar arrangement, and that is, a bank is regarded as being granted a license to issue SVFs. As banks are subject to holistic supervision by the MA under the BO and are deemed to be approved to issue multi-purpose cards currently. So under such arrangement, if a bank wishes to engage in SVF business, it must, in accordance with Section 8N, to pay a license fee. Now, under the BO, if the banking license is suspended or revoked of a bank, the SVF license is regarded as being granted, automatically will be suspended or revoked under Section 8A, 8G or 8Y. Now, if the conditions set out in the provisions are met, well, the banking license of the bank will not be affected, and this is the most appropriate migratory arrangement, and we don't have to take on extra application procedures. The bank is deemed to be authorized to issue multi-purpose cards, so we think that the present arrangement is good enough.
At the last meeting, members asked how we define the remunerations and expenses of the advisors and managers. According to 8ZZ1, and the MA may, after consulting the financial secretary, determine the remuneration or expenses to be paid by a licensee to the advisor or the manager. In defining the such expenses and remuneration, the MA must ensure that the remuneration and fees will be set at a reasonable level, and also such fees could be the subject of review by the tribunal. Finally, the MA may, after consulting the FS, use the exchange fund to pay the whole or part of the remuneration or the expenses payable to the advisor and the manager of the licensee. So we're sure that the arrangement can take care of the remuneration and expenses of advisors and managers. Finally, we spend a lot of time discussing Division 7, which provides for the regulation of the ownership and management of the non-bank SVF licensees, with a view to ensuring the fitness and propriety of controllers, directors, and CEOs. In Subdivision 2, it is stipulated that if the licensee wishes to dispose of some of its SVF business, it must obtain prior approval from the MA, and if it wants to have any reconstruction of capital, it will also need to inform the MA, and the MA may have the right to object. And if all the shareholders are not controllers, then again the bill would empowers the MA to object to any person becoming a controller of the licensee if the MA is not satisfied that the person is a fit and proper person. We've also provided for the requirement that the person who manages the business of licensee must be someone with a relevant experience, and such arrangement should ensure that the licensee and the senior officers are fit and proper persons. Thank you. Any questions? If not, the Secretary just informed us that we have received a letter from CA Hong Kong regarding 2 of the provisions. That letter will be circulated to members later. And I believe the government has also received that letter. I read the letter very quickly. I believe the government has answered all these questions already. As ISPs, their responsibilities, I think, compared with someone who doesn't have a license, I think are different. Chairman, I note that the organization concerned has made a submission regarding 8C. We are looking at that provision at the moment, but before the meeting, we've considered its suggestion. Actually, at previous meetings, we've already deliberated on this point in detail. Regarding 8C, it is our requirement that no one can knowingly assist someone who is not a licensee to so 8C actually applies to all persons and not just the ISPs. The ISP could be one category of persons to whom this applies. That is, they cannot knowingly, assist someone who is not licensed to issue SVFs. I've said previously at the time that we've not imposed any additional requirements for the ISPs and require them to vet or check such public promotion materials and see whether or not they come from a licensed person. We believe that such arrangement I think that we have really struck a balance between that and the need to deal with unlicensed operators. So if anyone has a reasonable defense, then even if we were to breach this provision, it would not be an offense. The reasonable defense could also be very, very, the scope can be very wide. And I believe proper balance has been struck, and I don't think members had any objection to that either during our earlier deliberation. But I will be prepared to give a written response to that letter. Yeah, I think if you just refer to the provisions there, then you might not get the whole picture. Legal advisor, I think the government's response regarding Schedule 3 and 8A I believe the government has addressed the conflicts that may arise between 8A and 8B. I wonder whether the MA can explain under what circumstances would it allow for exemptions pursuant to 8A. Mr. Lee. Well, there are several grounds for exemptions. In Schedule 8, we're saying that there are several scenarios where exemptions could be granted. For example, if it is an incentive scheme or bonus scheme where the reward is not purchased with money, then such products will not be bound by the SVF legislation. Another one would be in respect of single purpose electronic platform or internet platforms, and where through such platforms the consumer can access online audio video entertainment. The usage of such is very narrow because you're talking about a single purpose electronic platform. Again, such platforms will be exempted. There are also some bonus point schemes, although such schemes sometimes could be the bonus points could be topped up. Let's say if the owner of the facility don't have enough mileage, then he will spend money to top up the bonus point. But that doesn't make it an SCV, but rather it only serves to enable the consumer to take out the value which has been stored in the facility. And therefore, we don't need to regulate such loyalty point schemes. And also, if the usage of the instrument is very limited, it can only be used at, say, in certain locations like university or school campuses, and can only be used to buy certain products, and the store value is no more than $1 million, then again they will be exempted. Legal advisor. What I want the administration to explain is the minimum standard under Schedule 3. And also the deadline for the redemption of the remaining value. At the last meeting, I think we already responded to a similar question raised by members. For most of the SVF in the market, there is no deadline, and I think members are aware of that. In most cases, I believe the MA would require that all the licensees must, according to the demand of the users, and where practicable, redeem the remaining value of the SVF as soon as possible. We've also said that there are in the market certain store value facilities which are issued for commemorative reasons, or only issued to only particular categories of clients, such as tourists. And if they're only valid for a specified period of time, we will not rule out the possibility that the MA will consider whether the disclosure is accurate and whether the scheme is unfair to consumers, and the MA would have to agree to those conditions so that they will be allowed to set a redemption period. Otherwise, they must follow the requirements in Schedule 3 to enable the users to, at any time, redeem the remaining value of the card. In our CSA, we will spell this out clearly, and members can look at that CSA at the next meeting. Any other questions? If not, then we can, go back to the clause by clause. I think last time we were up to Part 7 of the bill, And this time, I think we should be moving to part Division 8. It's C292 of the Blue Bill, and marked up copy 112. And we are starting from 8ZZZB. We will begin our clause by clause from here. Clause 8 ZZCB. Stored value facilities exempt from divisions 2, 3, 4, 5, 6, 7, and 9 of this part. Mr. Lee already explained to you those instruments, and we will look at it again. Let's also take a look at subsection 2. The MA may require the issuer or the facilitator of a store value facility specified in Schedule 8 to provide the MA with any information that the MA consider necessary for satisfying that the risk posed by the facility to the user or potential user of the facility are immaterial, or that the risk posed by the facility to the payment and financial system of Hong Kong are immaterial. And then the facility will be allowed if the MA is satisfied. And nobody, I think at this point I can invite members to also go to Schedule 8. Mr. Lee already told you about the different types of exemptions, and I think I've already also explained this to members of the first meeting. And this is at page 464 and page 403 of the marked up version. The first category that will enjoy the exemption would be the store value facilities used for certain cash reward schemes. For example, such cards issued by supermarkets can come under the definition of instruments under Schedule 8, Section 1. And normally it is it may be used for storing only a sum of money paid by the issuer, and a person who agrees to pay a sum of money for storage in the facility under the agreement with the issuer, and the money may only be used to buy certain goods and services provided by the issuer. Clause 2, that is a store value facilities used for purchasing certain digital products, and this product must be used as a means of making payments for goods and services that are delivered to or be used through telecommunication, digital or information technology device, and the payments are executed through such a device. For example, iTunes and Apple stores, where people can procure games, specific games or songs or movies through their cell phones, and all consumptions are made via that device. These are very specific types of transaction which doesn't need to be subject to the regulation.
Section 3 has to do with bonus point schemes. We notice that in the market there are, say, mileage cards, and normally the issuer, through such bonus point schemes, encourages people to buy more of the goods and consume more. We notice that for these cards, there may be a condition allowing the card holder to store some money into the card, and so that it can be spent together with the points accumulated. For example, for some mileage card, people afforded the chance to buy the mileage with money. We noticed that these cards come with a special purpose and backgrounds, and they're not used for general consumption. So that's why we provide for a special exemption for them here. And Section 4, as VF, stored value facilities used within limited groups of goods or service providers. And the aggregate value of such would be no more than $1 million. So we think that we don't have to have them subject to our regulation because the risk is very minimal. For example, for some university campuses, there may be cards for doing laundry, for air conditioning fees, and also photocopying cards. We don't want to bring these cards under our regulatory regime. So that's why we say that exemption can be provided to these cards. Lastly, stored value facilities used within certain premises. For example, in some department stores and chain stores, cards may be used within the premises only, and the amount of the float of the facilities doesn't exceed $1 million. So the risk posed to the financial market is immaterial. So that's why we are also asking for exemption to be granted to these cards. We believe that Schedule 8 covers all as the apps that do should be enjoying exemption, and we have struck a balance here, so we are providing exemptions for them. Mr. Raymond Chen, I want to ask about the bonus points scheme. The MA colleague said that in the market, people may, in relation to the mileage cards, will buy certain mileages with cash. But if the bonus point scheme is promoted extensively, say for example, you can pay a very small sum to buy a great number of mileage, say if they have new promotion tactics, so people will be encouraged to buy the mileage. So that would be very different from what you mentioned. Say they just pay up for the mileage with a small sum of money. For some bonus points, they may be sent as gift to friends. So they may be buying a lot. So it's difficult for you to ascertain the bonus points to be purchased. So let's take a look at Section 3, B, point number 2. We say that the user may use the points or units for making payments for the goods provided by the user or person, either by using the points or units together with a sum of money that is stored on the facility temporarily for the sole purpose of executing the payments. So that's what I meant. And for C, the sum of money so stored is not redeemable for cash. So even if the passenger buys the mileage with a sum of money, the sum of money cannot be redeemable for cash. Well, just like what we are seeing in Octopus card. If the scenario mentioned by Mr. Chan really appears, then that deviates from the requirements of Section 3. That's true, but then overall, the risk posed by such a scenario will not be very high. If we look at 8ZEZEZD, there is a special exemption for this scheme that will be dealt with separately. So there is flexibility to this bill. What we need to look at more is whether the proposed scheme is posing a very risk to the financial market, so much so that we need to regulate it. Now for Schedule A, we have a list of the schemes, but then on top of that, the HKMA still have flexibility to decide on which scheme will enjoy exemption or not. Overall, Schedule 8.3 has to do with the mileage schemes. Mr. Ng Lang Seng. 3C. The sum of money so stored is not redeemable for cash. Do we need the word 現金 in the phrase? Perhaps I'll defer to the drafting section colleague to explain. here. Thank you, Chairman. Bin yin and bin wai are similar in meaning. So it's not redeemable for cash. Well, that's its meaning. That is its meaning. You don't need that extra word yin there. I'm not trying to be picky here. Well, the sentence doesn't flow with the addition of the word in. Yes, we can go back and take a look and consider. Legal advisor, do you have a view on this? There isn't any difference between the two types of expression. I think the word yin here is quite superfluous. I agree. You mentioned several times, under different sections, that the ceiling of the amount is $1 million. How would you monitor that this will be the case? Recently, well, a lot of university students would like to photocopy library books. If the sum exceeds $1 million, what will you do? As stated in A to EZB, even if there is an exemption, we empower the monetary authority to ask for information from exempted organizations to prove that the risk they pose is immaterial. Well, going by your example, if there is the case you mentioned and the organization has been exempted, the MA can still issue a letter to the organization to ask for information to prove that the amount, the aggregate amount is less than $1 million and that it can still enjoy the exemption. Well, we have considered this already. And so that's why we say that the MA should be empowered to do something even if an organization enjoys exemption. Legal advisor for Schedule 8, Section 2, the heading is stored value facilities used for purchasing certain digital products. Digital products are the word. Well, the English says digital products, and in Chinese it's 電子產品. Well, we usually associate that with handheld computers and mobile phones and so on. If we use the word digital, we normally use the words 數碼產品 in Chinese. So would you consider adding the words digital here in the Chinese version, or changing the words altogether so that there will not be any confusion? Yes, we can consider that. Yes, please continue. PAS. Well, going back to AEZC, just now we referred to Schedule 8 on general exemptions. If some SVF fall under Schedule 8 and are exempted, but then the monetary authority may, after consulting the financial secretary, declare that a stored value facility specified in Schedule 8 is not exempt. Well, the reasons are that, say, if the MA, after looking at the product or the facility, that it is best that they be subject to regulation for public interest purpose. And also, even if the SVF falls under Schedule 8, the risk posed by the facility is not immaterial, then the MA can still take away the exemption. But of course, the MA should first consult the financial secretary. Now, if the MA intends to do that, it must give a written notice to the operator of its intention, and also tell it that its exemption will no longer be valid, and not less than 14 days will be allowed for the operator to make oral written representation, and the MA must consider such a representation before it makes its final decision. And if the final decision is that there shouldn't be any exemption, Section 8A 8W will apply. It means that the issuer cannot no longer issue this SVF, and also should not issue such a facility. So that is applicable for 8W. Now, 8ZD deals with the situation mentioned by Mr. Raymond Chan. If SVF falls under Schedule 8, but not, or partly, but not entirely, falls into that schedule. So the MA will exercise flexibility. It will look at the risk posed to the potential users of the facility and the financial system in Hong Kong, and it will look at whether the premises where the SVF is used, the range of goods or services of the facility, the group of people to whom payments may be made, and also whether the risk management work is proper, and whether the company is financially sound, and whether the person can discharge his responsibilities properly. So if subsections 3 are satisfied, even if the SVF doesn't fall into Schedule 8, then the MA can still grant exemption. And for such exemption, the MA can impose certain conditions and also ask the operator, even if it is granted exemption, must notify the MA of the matters relating to the facility. And also there may be a condition regarding the maximum value of the sums of money in that facility. So the MA can have flexibility in giving special exemption under special circumstances. Section 8 ZE now states that if the MA revoke the exemption, it should do so through gazetto. And it should stick to procedural justice, and it should give 14 days for the concerned operator to make oral or written representation. And when it makes its decision, after it has made decision, it should give an official notice to the operator. If you don't have any further questions, then let's move on to Division 9, Miscellaneous. 8ZZZF requires the MA to keep a register of licensees. The names of the licensee, the address, the license number of the licensee, and any particulars should be kept in this register. Subsection 7 states that the MA must make the register available for inspection by the public in the form of an online record. Subsection 6, the register is to be kept at the office of the MA. If the license is revoked or suspended, the MA must delete the relevant records and also make a notation beside the suspension notice so that the members of the public can know which licenses are being revoked, which licenses are being suspended, and who are operating illegally. 8ZEZG states that if the MA has signed and certified certain documents, a true copy of an entry can be admitted as evidence in criminal or civil proceedings.
8ZZH is about winding up of licensee and protection of float. I think we've made reference of the banking ordinance. So 8ZCCH doesn't apply to banks because Section 122 of the banking ordinance already applies to banks. This section stipulates that for the licensees that the debtors, the creditors' voluntary winding up do not apply to the licensee. And in subsection 7, if there is a winding up of a licensee, and before we put up a petition for winding up, if the MA has taken assigned a receiver to take over the operations of the licensee, in the end there is a winding up order, and the court has already ordered for the company to be wound up, then the starting time for the winding up should start from the time the MA appoints, a receiver. And subsection 5 states that Section 182 of the Companies Ordinance does not apply, because Section 182 of the Companies Ordinance, in respect of the companies which are winding up, does not invalidate any disposition of the business or property of a licensee made. It will not be invalid if the MA has appointed a manager to take over the business or property of the licensee, and the manager has actually done that. Then the Section 182 of the Companies Ordinance will not apply in this particular situation. This arrangement is similar to the arrangements for the winding up of a bank. 8 CCCI is about display of license number on store value facility. If the SVF for the SVF that must ensure that the number of licenses is clearly stated, and if some SVF operated via the internet, then on the internet it should be the license number should also be clearly provided online. Anyone in breach of this requirement will be subject to penalty. As to what is meant by a physical device or device-based, a device-based means that there would be a physical device such as a telephone. That is what we mean by a device-based SVF. The others would be the SVF online. For both, we would require the operator to stipulate the license number, so that for the attention of the users. 8ZZJ, it's in respect of advertisements. We require that if a person must not publish an advertisement relating to the SVF unless the advertisement relates to the issue of the facility by the licensee, and that the license number held by the licensee is clearly stated. In Part 4, there is Part 4 provides for a defense. For anyone who disseminates such an advertisement, if he has reasons to believe that for a contravention of subsection 1, the advertisement related to the issue of a store value facility by licensee, and also so regarding the publication of advertisements, I think we've already raised a written question before. The definition of advertisement sometimes is not very clear. So if it is, provided for in writing, that would actually help facilitate enforcement. So would you consider providing for a written definition? And for ZZZI, if the device is in the internet, you say that it should be. I think internet normally we normally refers to the internet or the or websites. So operationally, I think it would be better if you could provide for a definition. Let me answer the question relating to 8ZZJ, definition of advertisement. We'll go back and think about this, and it's very likely that we will move a CSA to provide for a definition of advertisements, including any invitations or anything that will induce someone to use the SPF. We know that at the first few meetings, some members refer to some issuers overseas. What happens if they publish an advertisement in Hong Kong? Would they be deemed to be operating an SVF in Hong Kong? I think we've explained this point very clearly. And under ZZZJ, we will be moving a CSA, including the point raised by the legal advisor, the definition of advertisement, and also the views put forward by members in respect of this section, especially operator or issuers, and under what circumstances they will not be allowed to operate an advertisement overseas. Regarding the legal advisor's second question, communication network, do we need a definition for that? Whether it refers to a particular website or I think we can certainly go back and think about this. Perhaps I can take this up with our law draftsman to see how we can further clarify this point. Our intention is very clear. That is, those who provide for such tools on the internet, they must clearly, display or show their license number. Mr. Ng Sing, if the issuer has other products, for example, the bank has many retail products, and the SFF and the advertisement is only ancillary to the SVF, so would there be any special treatment? And would the banks be in breach of the relevant regulations? Thank you. I think the treatment is the same. We also go by 8ZZZI and J. That is, if a particular bank put up an advertisement in the bank, advertising is SVF, and provide for a general offer or a promotion or invitation, then the bank will have to show the license number for the SPF. The advertisement must also stipulate what is the SVF that it operates. ZZZI and J, I think both sections apply to banks, so all the operators will be treated in the same manner. In other words, it cannot be ancillary to the other products. The bank must, have a specific advertisement for this product alone. No, under 8ZZZJA, we stipulate that the advertisement relates in whole or in part to the issue of the facility by the licensee, which means that if a bank puts up an advertisement advertising other products besides the SVF, that would be allowed. But in its advertisement, if reference is made to the SVF, then it must also give its license number in respect of the SVF. Please carry on. We now come to 8ZZZK. A person who is not a licensee must not describe themselves in whatever terms as a licensee or behave or otherwise hold themselves out in a manner which indicates or which is reasonably likely to be understood as indicating that they are such a person. We will not allow for that because that would be misleading the consumers. And when that situation arises, where the person is not a licensee, person making such a description is making a false statement, and there will be a penalty. Legal advisor. Regarding ZZZK, well, if the person describes himself as the licensee, is it possible that a person would describe a third person as a licensee when in fact he is not? Do you have a provision to prevent that from happening? Thank you. 8ZZZK only targets against anyone who describe himself or falsely claim himself to be a licensee. Only in this situation will they be covered by 8 CCCK. If he describe another person as a licensee, that would not be caught by 8 CCCK. So how can you prevent, for example, by saying that Mr. Ng Leung Sing is a licensee, you can buy SVF from him? I mean, it's the same as my me claiming myself to be a licensee. Thank you. I believe that scenario, in this particular scenario, the consumer would need to, refer to our register, which is actually, accessible to anyone to find out whether someone indeed is a licensee. Or like yourself said, Chairman, if somebody all of a sudden claims that a third party is a licensee, and this would be misleading the public. I believe this scenario will rarely happen, but if indeed it does, the MA would have will remind the public that if anyone should falsely claim that a third person is a licensee, and the public needs to know about this, I believe the MA would, in the light of such circumstances, make an appeal to the public. I think this section is about someone who falsely claimed to be the licensee of the SVF. The SVF will need to be a legitimate SVF. Or is it the case that the SVF can also be fake? That he falsely claim, or he come up with a fake SVF, and then he will still be caught by this section. I think in both cases they'll be bound by 8 ZZZK. I think this licensing regime is such the license is issued to the company. For anyone who does not belong to the company and he claims to be a company that is licensed, then he would be in breach. If he doesn't claim that he is a licensee, he talks about a different SVF, which is also issued by his own company, but he is not a licensed person, he will still be subject to 8 ZZZK because he is not a licensed company, because he doesn't hold a license. It's held by a different company. In this case, I believe 8 ZZZK1 can cover the scenario which Mr. Chen referred to. Please move on. Next, invite Ms. Lee to carry on. We now come to section 18, where we will add part 2B. This is because we've expanded the scope of regulation under the bill, and therefore the terms of reference of the MA is also expanded correspondingly to cover the stability systems and the SVF, this payment system. 19, terms of reference of the the MA. Other than supervising the settlement system and see whether the obligations are complied with, and also to ensure safety and efficiency, it should also cover all the different SVFs. In Section 20, we will amend the old, Section 11, because this part and in subdivision 2 have been changed. Therefore, we need to amend Section 11.
Clause 21 amends Section 12 of the ordinance. We want the MA to be able to discharge its functions more effectively, so we empower it to, by notice in writing given to a system operator or settlement institution of or designated system, request them to give certain information or documents. And on this particular request, we also add in certain penalties. The assistant legal advisor has given us certain views earlier, and we will take reference from similar penalties in other parts of the ordinance. We would also add in some summary offences ordinances penalties here. Clause 22, we would add in 12A, B, and C. 12A states that the MA may examine books, accounts, and transactions. And the specified person means a system operator, a settlement institution, a participant in a designated retail payment system, or a licensee that is not a bank. 12B states that MA may require report to be prepared by auditor appointed by the 4 types of specified persons. They can appoint 1 or more auditors to prepare audit reports for them. And they can also specify the period within which the report is to be submitted and the manner for submitting the report. And also specify whether the specified persons has got a good control system. And 12C empowers the MA to ask the licensee and subsidiary to produce books, etc., for examination. Clause 13 amends Section 13 of the ordinance. The MA may buy notice in writing, but in the original ordinance it says that it could give notice to a system operator or system institution to take certain action. But apart from that, we are adding the clause that the MA can direct a system operator or settlement institution to take action in relation to ensuring the safety of the facilities. We have also provided a defense clause here. A subsection 4 spells out the defense. It is a defense for a person if he has taken reasonable steps to ensure that the direction to which the charge relates was complied with, or he can show that he is not responsible for the aspect for which, the aspect where there is no compliance. Well, there are editorial amendments to Section 16 and so on. Clause 26 has to do with certificate of finality. The existing ordinance spells that the certificate of finality is applicable only to the settlement institutions, and so in this bill we should specify that the designated system refers to the clearing and settlement system. Clauses 27 to 28 amend sections 30 and 31 of the ordinance. We added in the relevant penalties. The assistant legal advisor, the legal advisor has advised us on taking reference from the relevant clauses related to the summary offences ordinance. So we will do that. Legal advisor, with regard to 2B, we see that the MA is empowered to do certain things, and there is a defense clause. I have asked in my letter that, well, since the MA can ask for a lot of documents to be provided to him, but it is silent on documents which enjoy special privileges, for example, legally privileged documents and so on. LLPs documents. So how do you deal with such LLP documents? In our written response to the legal advisor, we have already covered that LLP is a very important right and is enshrined in the Basic Law. In our bill, there is nothing depriving of anyone who can enjoy and claim LLP. Well, we would not especially provide for that. Well, unless you want to deprive anyone of certain rights, we want to revise certain rights protected or afforded in other ordinances, the LLP will be treated by the common principles. So the fact that it is not there doesn't mean that we are not dealing with it. Anyone, including the lawyers, can claim such LLP under the Basic Law. Thank you. We agree that LLP is a constitutional right, and it is there even if it is not stated categorically in the bill. But we noticed that in recent years, the LLP is mentioned in the bills. For example, for the Securities and Futures Bill, Section 380, subsection 4 and 5, unless provided otherwise, the LLP is provided. And Section 5, the legal practitioners, whether they obtain their qualifications in Hong Kong or otherwise, and they practice as solicitors or barristers, they can enjoy LLP. So the provisions are clear, clearly set out the scope of the LLP. So my view is that if we can have this similar arrangement here, then that would be clearer for everyone. And or else people will be taken to court first, and then they can claim LLP in the court. This is not undesirable. Especially in Part 3A, the problem is even more poignant. Because in the investigation by MA, then it may get in touch with LLP documents. If we can deal with it in the same way as that in the Securities and Futures Bill, then that would be more desirable. P.S. We can study this together with the legal draftsman. My initial response is that for such LLP in the interpretation of the court and also application in Hong Kong, there have been many cases where the LLP has been interpreted and the scope is clearly defined. Now, is it the case that it will help if something similar, something suggested by the legal advisor is written? The Basic Law gives protection to this right. Is it the case that if we have it written down here, then the scope of protection will be the highest or greatest? We have to tread carefully on this. If we write that in, maybe unintentionally, we are actually narrowing down the scope of protection, and there may be disputes in the future. So that's why we don't want to include it in here. Since the legal advisor has such a suggestion, perhaps we can study it with the legal draftsman. Perhaps you can take reference from recent cases. Let's move on to Part 3A. C344 in the Blue Bill, and that has to do with the investigation power. Well, under different ordinances, there are sections on investigation. The legal advisor mentions about the Securities and Futures Bill and also anti-money laundering bills and ordinance. Similar powers are provided. 33B provides that the MA, if it has reasonable cause to believe that an offense may have been committed, a requirement has been contravened or condition has been breached, the MA may ask one or more of the persons under its in its office, and also with the consent of the financial secretary, to do the investigation. The fund will be paid out of the exchange fund. And for Section 33C, it sets out the power of investigator. For example, 33C requires that the investigator, if he has reasonable cause to believe that the person is in possession of a record or document relevant to the investigation, and he may, by notice in writing, require a person to produce that document and also reply to written questions, and also try to provide details of certain information requested. The investigator may give written notice, and he should present the relevant document. And 33D is drawn up based on the Banking Ordinance, Section 183, and that is the investigator may require a person to verify by statutory declaration the truthfulness of his submission. If a person does not produce a record or document, and in accordance with 33D2, the investigator can also ask the person to verify by statutory declaration the fact and reason. And say if ultimately, if the person is found to be telling lies, then well, if he does a statutory declaration, he will be dealt with accordingly. And 33E requires that the investigator may give interim reports to the MA, and on completion of the investigation, submit a final report. Subsection 3 requires the MA may, with the consent of the Secretary for Justice, publish a report. Mr. Ng Lan Sing, can I ask a question on this? Why do we need the consent of the Secretary for Justice? Interim report may be given, a final report may be given. Why do we need the consent of the Secretary for Justice? What is the difference between the interim report and the final report? In certain cases, the investigator may investigate whether a person has breached this ordinance, and ultimately we may have to initiate a prosecution, and we have to consider the relevant procedures and study whether we should make public the report partially or in full. So that's why we ask the MA should only publish a report after the consent of this S4J has been obtained.
Please carry on. 33F, offense for contravention without a reasonable excuse, that is failing to provide the information, or the information provided pursuant to the investigation is false or misleading, or that during the investigation he provides false or misleading records or information, that would be an offense. And any officer or employee of a corporation commits an offense if the officer or the employee, with the intent to defraud, causes or allows the corporation to fail to comply with the requirement and provide false information. The relevant offences, I think we've made reference of similar ordinance, including this SFO Section 184. Next, 33G. Where necessary, the investigator may apply to the court of first instance. That is, if someone fails to comply with the requirements of the investigator, then the investigator may apply to the court for an order. requiring the person to, within a specified period of time, comply and provide the information. If the person still does not comply with the order of the court may, pursuant to 33G2B, penalize that person. And the penalty is that person is deemed to have been found guilty of contempt of court. 33G and 33F cannot be used concurrently. For 33F, we can prosecute someone for failing to provide the information. But at the same time, the investigator cannot apply to the court for an order requiring that person to provide the information. So the two cannot be invoked concurrently. So and 33G4 has clearly explained this point. Next we come to 33H, use of incriminating evidence in proceedings. In the course of the investigation, inevitably we may require the person who is the subject of the investigation to make an honest reply. If the person cannot, just because such responses is self-incriminating, refuse to answer the question or provide the information. However, if it is likely that his explanation or responses would cause himself to be incriminated, then the investigator must beforehand give him a reminder that 33H applies in this case. And where 33H applies, then even if the investigator obtains the response or the explanation, he cannot, in a criminal proceeding in court, submit such responses and explanation as incriminating evidence against that person. So 33H, it's commonly found in other provisions relating to investigation, like the 187 of the section 187 of the SFO. 33I, lien claim on record or document. If someone claims to a lien on a record or document, then handing over such a document will not affect such authority. This is, I think we've made reference of a similar provision in the Securities Ordinance. 33J, the magistrate may authorize the investigator to enter the premises of the operator to search, seize or remove a record or document for the purpose of the investigation. 33K, if any person has a reasonable cause to believe that the person who is granted a warrant by the court may require the persons employed at the premises to surrender documents and require the employee at the premises and stopping them from removing any record or documents from the premises or deleting or interfering with any the authenticity of such documents. The warrant would also authorize the person to take all reasonable steps to preserve such documents and to prevent the records from being interfered with. Anyone who stops the execution of the warrant without a reasonable expense would be, in offense. 33L, record or document removed by persons authorized by warrant. Normally, the investigator can keep the documents for 6 months. If the record is eventually used for any criminal proceedings, then it could be retained for a longer period. And even if the investigator is in possession of certain documents or records, we would still allow the persons to, within a reasonable period of time, inspect such documents or make copies of such documents of the MA or the investigator. 33M, production of information in information system. All information contained in record or documents must be produced in a legible form. If the document is not in a legible form, the investigator may require the person to convert it into a legible format for the convenience of the investigator. 33N, inspection of record or documents ceased. If anyone would anyone can ask the investigator for copies of the documents so that in order to inspect it or to make copies. 33A, prohibition of on destruction, etc. of record or document. Nobody can destroy, falsify, conceal, or otherwise dispose of any such documents. Any questions? Legal advisor. My first question is about the investigator. Would you have a provision to deal with the responsibility of the investigator to ensure that the information is kept confidential and that it will not be leaked to other unrelated parties? In Section 50, the confidentiality provision, I think perhaps when we come to Section 50, we can go into that. 3B, Part 3B, is about sanctions. And we've added certain provisions here so that the regular persons, anyone who should breach the regulations, then the MA may, through civil proceedings, punish or sanction the operator, the settlement organizations, or the participants, or the licensees, or the senior, officers. So these are civil penalties, which we don't have to go to the court. But these sanctions are to be subject to review by the tribunal, and the sanction may include, a warning, a reprimand, a caution, a warning, or a fine, a maximum being $10 million, or 3 times the amount of profit, gain, or loss avoided by the person as a result of the contravention. It also, pursuant to 33Q, a moratorium could be imposed to stop somebody from becoming a controller or a licensee if we cannot satisfy the requirements of the regulator. In enforcing such civil sanctions, the MA may make the final decision pursuant to 33Q3. That is, the circumstances under which the offense takes place, the seriousness of the contravention, and the extent of the failure of the regular person to cooperate with the investigation, whether he obtained any economic benefits, and how much has he lost, and also the duration of the breach. Is it repeated breach of the or one-off breach of the ordinance? All these will be considered by the AMA to determine whether or not it would impose any civil sanctions against the person. If the MA decides to impose a civil sanction on the person, then pursuant to 33R, it will have to follow certain procedures. And we would require the MA to, first of all, issue a written notice to the regulated person stipulating that there's a chance that a civil sanction will be imposed, and the person will be allowed 14 days to make an oral or written submission. After that, the MA must consider such submissions before coming to a final decision, and the relevant decision will also be subject to review of the tribunal. 33S is about the penalty or the fine must be paid within 30 days, and such fines are treated in a civil court as a statutory order, and the orders and the fines collected will go into general revenue. 33T, monetary authority's power to take further action, that is, exercise the powers pursuant to the ordinance repeatedly. That is, if it is in the public interest or the interest of the consumer, the MA may come up with further sanctions when there are repeated offences. 33U is about the MA having to give public notice of the imposition of sanctions. 33V is about it stipulates that the application of sanction in relation to the former regulated person. It's not the case that if the person is left the company, the MA can no longer impose any civil sanctions on him. 33V said that even if the person were a former employee, a former licensee, he would still be subject to such civil sanctions. That is, we can exercise our power to warn, to reprimand the person, or require him to pay a fine. 33W, the sanction also applies to the senior officers. If the senior officers if the senior officers, aid, bad counsel, procure, induce the officer of corporation to commit the offence, the MA can impose a civil sanction against such person. Legal advisor, thank you. I note that 33V is about regulation of former regular persons. I mean, this could be extended to, a very long period of time. But in the spirit of law is that very often there is a time limit. But if you refer here to the former employees, then and there is no time limit. Wouldn't it be better if you were to impose a proper time limit? Yeah. Madam Secretary, perhaps I can invite the DFJ and the MA to make a supplement here. My understanding is that in other ordinances and when there are civil proceedings, there might be a limitation which may apply here. Who would like to supplement? Lord Drossman. Mr. Chairman, normally for civil proceedings, our understanding apparently is that there is a time limit. That is, starting from the time the incident happened, we will allow for a time period. If I remember correctly, it's 6 years. I can go back and further confirm what is the usual time period. Normally, we will not provide for this in the law. Perhaps on this point, I can go back and check and give you a written response. Carry on. Next, we come to Part 4, which are consequential amendments. Section 30 amends Part 4. That is the appeal tribunal. We've made some consequential amendments here. We've created a new Part 2 of the new schedule. If you have the blue bill, you may refer to page C428. All the persons who are likely to be regulated are spelled out here. And these are called reviewable decisions.
These reviewable decisions can be subject to review by the appeals tribunal. And because of this bill, as names were changed, the appeals tribunal will be renamed as the Payment Systems and Stored Value Facilities Appeals Tribunal. Clause 31 has to do with the name, the change in the name. Clause 32 amends sections 35 of the ordinance, and it has to do with reviewable decisions. And the aggrieved party should lodge an appeal within 30 days. And we have revised this ordinance to add in the new references. Clause 36, powers of tribunal. We have added in the new penalty. We have taken reference from the penalties imposed by the past tribunal, and then that's it. We haven't added anything new. I have written in to ask, and the administration has given me a written response. Certain decisions of the monetary authority are not subject to review, or is not in part 2. So can you explain to us which decisions are not subject to review and why? Can I refer members to page C428 in the Blue Bill? The reviewable decisions have been listed. We have discussed this several times internally. What are the reviewable decisions? Decisions to grant licenses, granting of licenses, refusing to grant licenses, revoking of licenses, suspension of licenses, and also revising the fees, and also certain matters which have to be approved by the MA, and also exemptions, and 33Q are decisions relating to the civil sanctions. These are decisions which can make people feel aggrieved, so these are included in the reviewable decisions. We have actually gone through this table several times already and see whether there are other decisions which should be reviewed, but I can confirm that Part 2 lists all the decisions which should be reviewed. Legal advisor, in your written response, you listed A to F, decisions which could not be reviewed. Can you explain what these decisions are? Thank you. These decisions are not targeted at certain individuals, I must say. Say if the MA revokes the appointment of an advisor or manager, or the MA cancelled certain licensing conditions. Well, these decisions will only make things better and not worse for the licensee. So these decisions should not be considered as reviewable decisions. So these decisions do favor to the licensees. So these should not be reviewable decisions. Conversely, if decisions which make things worse for the licensee, then these are reviewable decisions. Please move on, legal advisor. In your written response, A to F, I have questions on 2 items. Item A, 8A, bracket 2, that has to do with the MA, announcing that certain persons are not managers. Well, you may specify certain people could not act as managers. So these are the people who may feel aggrieved and they would like to lodge an appeal. Another 8, is that you? Cancelling the appointment of certain individuals, say, for example, the managers. The manager may feel aggrieved about the cancellation of his post, and also the facility users may feel that they would like to have this manager staying on the post because he's doing a good job. The MA may cancel the post, and then the user, the facility users, may feel aggrieved about the cancellation, so they would like to make an appeal. So can you give us some more information on these 2 scenarios? Perhaps you can go back and consider these 2 scenarios more. You mentioned about the manager. well, the manager is not the main target for the licensing regime. Now, if MA announces that the manager should no longer be the manager and he feels aggrieved, we can consider adding that back. But then I think the chances of him feeling aggrieved are very slim. You mentioned about whether consumers will hold certain views on the appointment of the managers and so on. I think this is a far-fetched scenario, and the chances of that happening are very slim. I think we can consider the point made by a legal advisor, but to my understanding, there is a very little chance that the licensee will feel aggrieved because of that, so we don't want to add that in. The reviewable decisions are really for the licensees to have certain decisions reviewed and not other parties to lodge an appeal. But that doesn't mean that other parties cannot exercise their rights to get the case reviewed by the court. Well, anyway, we will take on board the legal advisor's views and we will consider. Can you see to it that whether your proposal is in line with the civil aviation law? Let's move on to Section 40. It's also a consequential amendment. The Chief Justice can review Part 1, and that has to do with the certain procedures of the tribunal, and the Chief Justice may draw up certain procedures. Then, Sections 41 to 44, and by Section 35, these will be deleted because all the provisions relating to penalties, they have been moved upwards. So Sections 41 to 44 will be deleted or repealed. Section 45, giving false information to MA. And anyone who does that will commit an offense. And Section 46, misrepresentation in respect of designating system. And we have made consequential amendment here in relation to the wordings. Section 47 and Clause 38 of the bill. A person who makes a false entry in an information system commits an offense, and that is already in the original ordinance. So we added in stored value facility and also this designated system. So that's the case. Section 48, the amendment is to ensure that the company officers are liable, and they will be subject to penalty if they commit an offense. If they help in the capacity as a senior officer the company to commit an offense, that officer commits an offense himself and is liable. And also, Section 49, legal advisor. 47, penalty. We will add in the other suggestion you made. 40, Clause 48 amends Section 49, and that has to do with the power of the MA to make regulations. The MA, we will empower it to make regulations for better carrying out the purposes of this ordinance. With regard to designated system, the MA, after consulting the FS and the system operators and settlement institutions to make regulations. In response to certain submissions made by Octopus and the banking associations, we will consider moving on CSA so that in making regulations on SVF, we should consult the relevant licensees. Clause 41 amends Section 50 on confidentiality. The confidentiality provisions should be applicable to people discharging functions under this ordinance, including the consultant, the management person, and also the investigator. All these persons will be included. This clause doesn't apply to the people mentioned in subsection 3. And that is the public officer authorized by the financial secretary to do certain tasks. So the confidentiality provision doesn't apply to them. And also to the disclosure of information to the commissioner in relation to the anti-money laundering and counter-terrorist financing ordinance. On the condition that public interest is not compromised, the MA says that disclosure of information can be done with regard to disclosing the information for overseas organizations to ensure that the licensee's operations are safe. 49. MA's power to make regulations, or subsection 1. I have a question on that. It says that the monetary authority, they make regulations after consulting the relevant, the following people. A1 refers to the financial secretary, and 2 refers to organizations, system operators, and settlement institutions of designated systems. So, does the term persons cover organizations as well? Can I defer to the law draftment? Normally, when we use the word yan in Chinese, under the interpretation and general clauses ordinance, it covers corporations and organizations as well. So that can be used, right? So then that will be okay. Please move on. Well, we have provided for penalties under clause 50. If an offense is committed, there is a penalty, and that is provided in clause 12. In response to the legal advisor's point made earlier, we will add it in the summary of offences ordinance's penalty. Section 51, immunity. We have added the term an investigator. The investigator, if he discharges function under this ordinance, he is not liable to any criminal liability. And clause 43 amends section 52, and that has to do with the power of MA to require information to be given. We have expanded the scope to include the SVFs. So we have revised the wordings, clearing and settlement here. With regard to the penalties, we will also consider the legal advisor's suggestion of adding in the clauses under the summary offences ordinances. Section 53, requirement to give information relating to default. We have added in the relevant penalties. Clause 45 amends section 54 on guidelines.
The monetary authority shall discharge its functions and exercise its powers. We will have guidelines to assist the regulated persons to abide by those provisions. Clause 46, we've added 54A. To give the MA the power to specify the form of any document required for the purpose of applying for a license. The MA can specify the format. 47 actually is a technical amendment in respect of the address of the applicant, so that the the notice to be served will include the address. And next, 56A is about recovery of fees and expenses. Say, if, for example, the licensee owes the MA a license fee, then the MA may, through legal proceedings, recover the amount from the licensee. And this also includes remuneration expenses payable by the licensee to the consultant and managers. 49 amends 57. We've added subsection 2. The Financial Secretary may, by notice published in the Gazette, amend Schedules 3, 4, 5, 6, 7, and 8. Legal Advisor? Thank you. Beg your pardon. I want to go back to 54, guidelines. The original 2 was 2 that the M can publish through the Gazette any guidelines. Are these guidelines, part of the subsidiary legislation? No, they're not part of the subsidiary legislation, so it's not legally binding. In the course of supervision, the MA may use that to consider whether or not the regular person has complied with the guidelines. 50 amend 60 amend 58. Notice, etc., as subsidiary legislation. We've added 2C, 88, and 57 to announce certain persons as not being managers. So that would be a subsidiary legislation. 51. In 51, we've added section 60. This is about the savings and transitional provisions relating to the ordinance. I also like to invite members to go to Schedule 9, which are the transitional provisions. And in respect of, under the existing ordinance, for example, the chairman of the tribunal, members of the panel, and also under the existing ordinance, the notices already gazetted and so on, will continue to apply until the designated dates, expires. So if members have no questions, I think we may now go to Part 3 related amendments. That would be Clause 54 or 478 of the Blue Bill. And in Part 1, we basically amend the banking ordinance, and Section 54 amends the interpretation under the banking ordinance. We stipulate that bank deposits does not include what is referred to under Section 4, that is any float or the deposits for the facility. And since the banking ordinance regarding SVF, regulation of SVF and the transitional period, so therefore under Section 54, we would be deleting multi-purpose SVF and the definition of single purpose store value facility. 55 to 59, I think because of the provisions relating to multi-purpose SVF has been migrated, transferred to the clearing settlement ordinance, we will be deleting the relevant provisions in the banking ordinance. Section 60 amends Section 52 of the Banking Ordinance, which is about the powers of the MA. And for a particular bank, the powers of the MA also includes, for a bank which has a license to issue SPF, the MA's power under the Banking Ordinance may also apply here. Clause 61 is a technical amendment. 62 is also a technical amendment which deletes the provisions relating to the multipurpose SPF. We will next move on to Part 2, which amends the Electronic Transaction Ordinance. Since the relevant payment system and the SPF ordinance, once it comes into effect, then the name of the tribunal will be changed. And because of that, we have to make a consequential amendment to the Electronic Transactions Ordinance. Division 3, that is Section 64 of the bill, we will amend the Anti-Money Laundering Ordinance, that is Cap 615, Clause 5. We will delete the section which require the financial institutions which has to conduct proper due diligence exercise, and this applies to SVFs if the maximum float is more than $3,000, and if it is a device-based SVF to store the amount, then it will be subject to Schedule 2. For store value which is not stored in a device-based SVF, then the MA will in its licensing conditions enforce such a requirement. Section 65 add to the definition of premises the premises relating to the SVF. Section 66 amends Section 25 of the ordinance, that is for regulation of institutions operating money service as an adjunct service. If the organization already has an SVF license, then it will not have to apply to the C&G department for a money service license. So we have therefore taken this part out. Next, Clause 67 is about the money laundering ordinance. The interpretation under the money laundering ordinance is placed under Schedules 1 and 2. We have added the definition of SVF and the payment system. If we look at Part 4, the definition of financial institutions, we have added the licensee, SVF licensees. So I think that's all for the bill. With that, I think we have concluded the clause-by-clause scrutiny of the bill, and it's almost time to adjourn. At the next meeting, we'll be looking at the CSAs to be moved by the government. When will be our next meeting? The 9th of June at 2:30. So with that, I think we may now adjourn the meeting. Thank you.